Well, there is some more action in the Karen Reed case. So let's just remember where we are in Karen Reed, because there's a few different proceedings that are going on at the same time. Number one is we have the criminal case, which is set to be retried in January. Number two, we have the civil case where Karen Reed is being sued by Paul O'Keefe family. There's a motion to stay those proceedings pending the outcome of the criminal trial. We spoke about that in a previous video. If you haven't seen that, definitely go check that out. We also have the appeal, which is sitting in the Massachusetts Supreme Court with respect to the double jeopardy argument that Karen Reed's defense team is making. So we've got a number of different proceedings going on at the same time. Today, we're going to be talking about the actual criminal trial, which is supposed to be retried in January. And here we have a new prosecutor. As we all know, a new prosecutor is being brought in to try the case a second time. And he filed a motion, which we can only reasonably call a motion, although he did call it something else. Essentially, it's a motion asking the judge to allow some additional testing on the infotainment system within the Lexus that Karen Reed was driving. And we all understand how critical and crucial any data that we can learn and get from the Lexus. We understand how important that is to this case. It could be inculpatory, it can be exculpatory. So it's very important to get whatever data we can. And this is what the state is asking for, to be able to retest the infotainment system from the Lexus. Now, just to understand what happened in the prior trial, the first trial that happened. So we had Trooper Nicholas Garino, who testified about the attempts of extracting some information from the infotainment system. So just to kind of remember, or to remind all of you about what his testimony was, I'm going to pull it up so we can rehear again Adam Lally ask him some questions, which I know a lot of you missed Adam Lally ask him some questions. So we're going to play that for you. And we're going to hear, more importantly, what Nicholas Garino said, what he testified to about that attempted download or extraction of the infotainment system. So just to understand, there's two different ways to extract information from the infotainment system. One way was clearly not going to work. And now the other one is called a chip off. That's what it's called, a chip off. And the danger of doing a chip off is that once you do the chip off, you're at risk of losing any information that there is on the infotainment system. Like, it's your one shot and you may destroy the chip in the process. So that's what the chip off is. That's what they're going to be talking about when you hear chip off. So here we go. Let's play this for you. You'll all remember this. And this is what the testimony was with respect to the chip off. Here we go.
And as far as that chip-off process, who, if anyone, was present with you, or who, if anyone, assisted you in removing that or conducting that chip-off process with regard to the motherboard from the entertainment system from the defendant's vehicle?
I'm sorry, at the time that we actually did the chip-off?
Yes.
Yeah. It was myself, AG Speak, and Maggie Gaffney.
So those were just simply the people that were present when they attempted to do the chip-off.
And who is AG Speak?
AG Speak is has his own forensic company, I guess you could call it, for Burla. I could consider an expert in the field, former California Highway Patrol officer that exclusively handled stolen cars.
And who is Ms. Gaffney?
She was a defense's expert. She's the one who actually did the chip off, applying the heat and taking the chips off in our presence. And she, I believe, works for, I'm sorry, the name of the company escapes me at the moment.
Now, with respect to the information that you, Ms. Gaffney, and Mr. Speak were able to remove pursuant to that chip-off process, what, if any, usable information were you able to glean from that?
As I was told by AG, there was no data that was recovered off the infotainment system or the telematics module from the chip off.
So there you go. There was no information that they were able to extract from doing the chip off. So it was a complete failure. And again, we understand how critical that information is. So here, the state is simply asking, let's see if we can actually get some more information. And they have another expert who is going to attempt to get some more information. So let's go through the motion like we usually do, and we'll talk about it, we'll analyze it, and we'll see if there's any merit to it. So here we go. All right. Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus telematics system. Now comes the Commonwealth through its expert, Shannon R. Burgess. So here is the new expert named Shannon Burgess in the above captioned matter, and respectfully provides notice to the defense and this honorable court that it intends to engage in further testing of the defendant's Lexus telematics system. Mr. Burgess has opined that significant data was likely not acquired during the chip-off procedure, likely caused by programmer's error. Programmer is a technical term referring to hardware and software utilized to acquire and interpret data. So there was some sort of error, and that's why they were not able to get any sort of information out of this infotainment system. So first of all, I do apologize. I did try to make this as clear as possible. I hope you can read along with me. If you can't, well, I am going to be reading through it, and it's not that long, so hopefully we'll get through it pretty quickly. But I apologize. I did my best to do that. Also, this would probably be a good time to give a shout out to our sponsor of today's video, The Suit Depot. It is a great store, a lot of high quality apparel to make you look your best and very reasonable price. And of course, to all my specific listeners, you get, and you're not going to get this deal anywhere else, you get a 10% off coupon. All you got to do is type in Brother Counsel, no spaces, all lowercases on the coupon box when you are exiting the online store. So go ahead, hit that link in the description, and when you're checking out, make sure to type in Brother Counsel, lowercase, no spaces. All right, here we go. The infotainment and telematics modules from the defendant's Lexus were seized pursuant to a search warrant on February 2nd, 2022. On November 30th, 2023, this court, without objection from the defendant, allowed the Commonwealth's motion to permit destructive testing of the infotainment and telematics systems due to the means and methods required to retrieve this vehicle's data, right? So in order to permit destructive testing, you have to make a motion with the court, right? You can't just destructively test stuff and then say, oh, well, it's not here anymore to test. And the defendant was okay with that. So Karen Reed's team, they were okay with permitting this destructive testing of the infotainment system and see what they can get from it. On December 1st, 2023, the defense's expert, Maggie Gaffney, performed a procedure known as a chip-off, a digital data extraction and analysis technique that involved physically removing memory chips from the Lexus's infotainment and telematics systems. This procedure was observed by Massachusetts State Police Trooper Nicholas Garino, as we just heard him testify to. It was also observed by the Commonwealth's expert, AG Speak, who authored a report detailing the process and his findings. While a chip-off had the potential to be destructive due to the technique required to remove the chips, in this case, the memory chips associated with the infotainment and telematics modules from the defendant's Lexus were not destroyed. So even though this does carry the risk of destroying the chip or destroying any sort of information that you can get from it, well, guess what? It happened to be that it was not destroyed and along with the infotainment system, telematics system, and the Lexus vehicle, remained secured in evidence. So it's secured. Everything is great. Everything's fine. Mr. Burgess, through his training and experience, believes the evidence acquired in the chip-off was incomplete and that more data that was not acquired exists on the chips. Hardware and software updates have developed since December 2023 when it was first tested, including but not limited to an updated version of Burla's IVE software. These updates were not available at the time of the original testing. The likely deficiencies from the original testing involve two modules in the vehicle that have the capability to store data, an infotainment module and a telematics module. So the deficiencies from this original testing were two major parts. One was the part of the infotainment module, and the other one was the telematics module. The infotainment module, MMU, includes a built-in diagnostic recorder designed to capture vehicle operational logs, how the car is actually driving. If a vehicle is equipped with navigation, the system can also record geolocation data in the form of track logs. The telematics module, so that's what's included in the infotainment module. The telematics module also has the capability to store track logs. Navigation events can be inferred from the start and stop points of time-based tracking. In addition, the modules may contain device connections to the vehicle and separately Wi-Fi connections to the module obtained and stored as the vehicle travels. Mr. Burgess identified that two potential data-bearing components were removed from the MMU and identified a 64 megabyte flash memory component and a 16 megabyte EEPROM. The prior readings resulted in 3 files, 8 megabytes in size. So that's only 8 megabytes, 3 files of 8 megabytes. And really, there's a 64 megabyte, some sort of a memory there. Mr. Burgess opines that the acquisition of files in December 2023 should have been closer to 64 megabytes. So those files, they came up as 8 megabytes. Really, those files should have been closer to 64 megabytes. That's a lot more data than 8 megabytes, right? Believing that the discrepancy likely resulted from deficiencies in the hardware and software used at the time to interpret the data. So why did that happen? Why was it that they were only able to get 8 megabytes? Well, that's because there were deficiencies, there was errors in the hardware and software used at the time that they tried to download this information from the chip off. Mr. Burgess determined that 3 potential data-bearing components were removed from the DCM. Similarly, Mr. Burgess identified that 2 of the components, Micron JWB57 and Micron, this other name, likely contained incomplete data acquisition, likely resulting from the hardware and software used at the time. Okay, so this Micron JWB57 only produced 554 megabytes acquisition and should have been near 4 gigabytes. Wow, so that's a tremendous difference of data between 540 megabytes and 4 gigabytes. And again, this Micron, whatever this name is, only netted 264 megabytes and should have acquired around 2 gigabytes. So there is a ton of information, according to this expert, Mr. Burgess. There's a ton of information that now he thinks that he's going to be able to retrieve instead of just whatever they actually did retrieve back then in 2023, which was a lot less. Based on these likely deficiencies in the acquisition, Mr. Burgess has recommended a review of the chips that have previously been removed and subsequently a reattachment of the chips to the board in the defendant's vehicle. So that's what he's suggesting. Let's remove it again, and then we'll reattach it again, and we'll be able to see maybe we can get some more data. Mr. Burgess would employ updated programming and current software versions to maximize the chances of a complete acquisition. Mr. Burgess believes the use of a variety of different hardware programs and updated software will yield a more fulsome acquisition of data. Mr. Burgess has provided a detailed outline of the procedures and efforts he would employ. So he put that into his affidavit, showing exactly what he's going to be doing step by step. And obviously, anyone who wants, is interested party can obviously watch him while he's doing all this if the judge approves this. Given that the testing is potentially destructive, the Commonwealth is providing formal notice to the defense and an opportunity for the defense to employ its own expert to be present during the different stages of further testing. Now, let's remember, this motion essentially was already filed. They already filed this without the objection of the defendant to be able to do this testing, even though it potentially is destructive. So really, this is just another notice saying, hey, by the way, we're going to rely essentially on that previous order, or we want to rely on that previous order, which the defendant did not object to. After all, if Karen Reed agrees and is maintaining her innocence in this and that she never did anything like this, so then why would she care about having testing done or further testing done for the Lexus? The first stage of testing would occur in Texas, and the subsequent testing procedures would continue in Massachusetts. So if they're going to hire an expert, guess what? That expert's going to have to fly him out to Texas, and then they're going to have to come back to Massachusetts. The testing is necessary and could produce relevant and material corroborating evidence for trial, which I think we all can agree on. This evidence, again, if this was all sabotage and the state actually was playing around here, and this is a conspiracy, well, then maybe all this evidence is not going to be so exciting, because whatever evidence they're able to get from the Lexus, well, that could be what the police were doing. Nevertheless, still, obviously, the more data that you can get from the Lexus, the more can tell of more full story. This evidence may be exculpatory or inculpatory. We don't know. It could be that this evidence will show that Karen Reed is 100% innocent, clearly. So definitely that she should want this testing should be done. Track logs are essentially an ordered sequence of GPS coordinate measurements stored by a satellite navigation system. Unlike telephone satellite data that are employed in triangulation analysis to place a cell phone in a general area, track logs provide specificity. So if they can get this track logs, they can really see exactly where that Lexus was. Generally, track logs are points that are automatically stored when a device is moving. This information is tantamount to laying down a breadcrumb trail memorializing travel by location and time. The download analysis by Mr. Burgess and use of other software may also provide information about any other devices connected to the vehicle, i.e. phone, and could potentially identify any Wi-Fi connections that would identify by the vehicle as it traveled on its route. In the case at bar, track log information is significant, as we can all agree. If track log and other various data information exists, it will serve many important functions. The benefit includes corroborating the defendant's travels before, at the time, and after the defendant's Lexus vehicle was involved in a triggering event. If track log and Wi-Fi information is retrievable, the data would provide independent corroboration to the numerous witnesses who made observations that the defendant's Lexus was parked in front of the Fairview Road address after midnight. Further, the data would identify the location of the defendant's vehicle at the time it engaged in the impact event and provide the time and location of the defendant's travel from the scene to the location of Mr. Keefe's home. So now, obviously, everybody understands that it's crucial. It's very, very important information to know at what time was that Lexus in front of the house. Everybody knows, everybody agrees that it was there at Fairview Road. The only question is going to be, how long was it there? When did it leave? That's a very important question. So that's going to be very helpful to the case. The Commonwealth provided and introduced a trial video depicting some of the defendant's travels on January 29, 2022. The additional data likely to be retrievable would assist in identifying the precise locations that the defendant's Lexus traveled from the time that the defendant struck and killed Mr. John O'Keefe. Okay, a big jump there and a big conclusory statement there. Until, okay, that's a little typo, the time the vehicle was seized. The Commonwealth respectfully requests a hearing within the next 14 days to permit prompt testing and production of relevant discovery, whereas this matter is scheduled for jury trial in January 2025. So they want this set for a hearing within 14 days so that they can get this ruling that they are able to go and retest. Let this expert go at it. There's a whole hunk of data that we can really get from that chip off. The chip off did not destroy last time. There's no reason why the defense should oppose this the same way they didn't oppose it last time. There's no reason why they should oppose it. And we'll see if they actually do oppose it. But essentially, if she maintains her innocence, and maybe this could be more data showing that she's actually 100% innocent and that she never actually hit John O'Keefe, well, then why should the Karen Reed defense team oppose this specific request by the state to have this chip off attempt again, even though it may destroy it, but you're okay with it the first time, you should be okay with it the second time as well. So we will see what happens with this, and we'll see, actually more importantly, what type of information and data they'll be able to get, because most likely the judge is going to grant this just like she granted the first time. And unless the defense can come up with some sort of novel argument why the first time they decided that they weren't going to oppose it and they had no objection to it, why all of a sudden they're changing their mind. So we'll of course, we're going to monitor this like we do with some of the other trials that we're following, and we'll see if the defense opposes this, and eventually we'll see what the Judge Canoni, is going to rule, although I have a feeling that she is going to definitely allow this expert to retest it again. Again, the defense can say, well, this is cumulative. It's not really going to add some more information, but really, according to this expert, there is a whole hunk of information that they weren't able to get the first time. So why not be able to get this more information this time, the second time? So we will see what happens. They're asking for a hearing within 14 days. We'll see if that will happen. And of course, we will bring you the update and analysis that you are looking for. So that's going to be it for today on the Karen Reed case. We are also closely watching the Sarah Boone jury trial, which jury selection started off today, and we will see how quickly they go through jury selection, and then eventually they'll move on to the trial. Just a little bit of a heads up and a little bit of a damper perhaps for some of you. There is a Jewish holiday coming up, which means that I'm not going to be able to completely cover every single day of that trial over the Jewish holiday. It spans the end of this week and going into the entire next week, which I will be out of commission. So we'll still, up until that point, we'll still keep tabs on what's going on with Sarah Boone. And then hopefully after the Jewish holiday, we will catch you all up and give you the analysis that you can't find anywhere else about the Sarah Boone trial. So that's going to be it for now. Please, if you haven't yet, subscribe, like the video, and we will see you next time.